ask the technician to put on the slide for this panel session, just the guiding slide so that you can see. Yes, there it comes. Indeed, I mean, I was very cautiously following actually all the discussion or the questions that have been posed, and we will collect them and try to somehow distribute them to all the panelists. We will put an effort in there. What I could see from the questions that were asked, I mean, essentially I could see two blocks there, and one block were referring to the international dimension that already was somehow addressed at this panel discussion. And I believe we will get back to that discussion in the following, not this session, but in the following session actually. So the Beyond Europe dimension of SEPs. I mean, there is clearly an issue, a lot of issues there. And the other dimension is really all about this creating transparency, and in particular the essentiality assessments that have been mentioned now already a couple of times. And this is what this panel is about. And I'm glad to be able to chair this panel, and we will continue in a way the discussion that has already started by the previous panel, focusing a lot more on the specific, really on the issue of essentiality assessments only. Kerstin Jona has mentioned, and I found this very interesting, that this is really a matter of reducing the scope of the potential for litigation, and I think that is what it is about. We have more players in this field with IoT and 5G technologies. A lot of them are actually less experienced with intellectual property issues, with patent issues in particular, with licensing issues. So, and of course, the technology is more and more complex. So, what is more obvious than somehow to increase the scope of potential litigation there, and that is really, if there were numbers mentioned out of the SEPs that have been declared for a good reason, for the front declaration, obviously, but there is only a limited amount of them that are really essential when they will ever get checked. And this is usually done nowadays within pools. Sometimes it is patent pools, sometimes it's done with courts as well, and there's different methodologies out there. We're not going to discuss them here in this panel discussion, but I would like to I'm really pleased to see that this issue is raising now has been such attention by policymakers. Kerstin Jona has been referred to. It was also referred to as a concrete example by Vice President Vestager in her speech on the 25th of November, mentioning specifically that the Commission can improve the framework in place for standard essential patents by, for instance, setting up an independent system of third-party essentiality checks and so on. So this is really really an up-to-date issue. And this panel discussion here, we would like to dig a bit deeper by the questions that I have set up. So, for instance, which entities are best placed to perform essentiality checks? What should be the legal status of an essentiality assessment? What can it be? What is a reasonable level of fees to be charged for carrying out tests, and who should pay for it? I mean, that will, in the end, I mean, that will be very, very important, of course, the costs. I mean, it was already said a couple of times as well in the previous discussions that anything that should be set up, regulation is fine, but as much as possible, I mean, it should be market regulated, self-driven. So in that respect, I mean, the costs that will come along for the people who will have to pay for it will be decisive. And then, of course, the issue of how this could actually be set up and institutionalized, this whole issue. I'm pleased to see the panelists that we have here on this panel pretty much representing important players, and also some of them were also participating to the pilot study that has been referred to a couple of times. So we have here on the panel, we have representatives from the European Patent Office. We have Michael Fröhlich, who is the Director of European and International Legal Affairs for the PCT and the European patent at the PCT at the European Patent Office. And then we have we have Christian Loyau. He's the Director of Legal Affairs and Governance of the European Telecommunications Standards Institute, ETSI. And we have Monica Magnussen. She's the Vice President of IPR Policy with the Ericsson Group. We have Beat Weibel. He is the head of the Intellectual Property Department of Siemens AG. And then we have Tim Pohlmann. He is the Chief Executive Officer and founder of IPlytics, a data company that is doing a lot of analytic work with SEPs. And with this, I would simply give the floor to the panelists for an opening statement. And we will start with the order that we have put here. So Michael Fröhlich, please. And I think we can remove the opening slide now, please.
Many thanks, Nikolaus, and thank you very much for having me. I hope you can hear and see me okay. Thanks. Let me start by saying a couple of words about the EPO and our involvement in standards. The European Patent Organization is actually the second largest intergovernmental institution in Europe. We're not an EU institution, but we're an international organization of our own, which is based on the European Patent Convention. As the Patent Office for Europe, our mission is to support innovation, competitiveness, and economic growth across Europe. And this is quite an important task, given that IPR-intensive industries generate 45% of GDP in the EU annually and account for almost 30% of all jobs. Did I just say 54? No, it's 45 of GDP. And actually patent-intensive industries, which make a major contribution to technologies of the so-called fourth industrial revolution, accounted already some 4 years ago for close to 2% of total EU employment and almost 4% of GDP. As regards the EPO's involvement in standards, we have a quite unique approach amongst patent offices, both in terms of patent quality and patent transparency. Indeed, we have a long-standing established cooperation with standard development organizations, have a well-established practice in using documentation that is produced during the standard setting process as prior art when searching and examining patent applications. Almost 4 million standards-related documents are available to our patent examiners who are well trained to use this documentation for their prior art searches. Over 60% of EPO search reports in key technical fields, such as, for instance, wireless technology or digital video coding, contain citations of standard documents that are eventually then relevant to the patent granting process. And this approach obviously contributes to optimize patent quality in relevant technical areas. Actually, according to an external study from 2016, this policy has been leading to around 10% fewer patent grants in these areas. The EPO's approach to SEPs is also unique in its contribution to enhancing patent transparency around SEPs. Actually, the databases of two major standard developing organizations, namely ETSI and the ITUT, both link with the EPO's patent information services, such as ESPASnet. This makes it possible for everybody to easily access relevant patent information of the declared SEPs by simply clicking a link in the ETSI or ITU database. And this then includes, for instance, information on the file wrapper, but also patent family information that you will find on our patent information services. Now, coming to the essentiality test. As already mentioned, the EPO, together with 5 national patent offices from our member states, has participated in an experiment in the pilot study for essentiality assessment of SEPs that has been commissioned by the European Commission. As mentioned by Nikolaus, the study investigated the technical and institutional feasibility of a large-scale system for an essentiality scrutiny of SEPs. The study followed a combination of approaches which was applied for this purpose, including a pilot experiment to investigate the technical feasibility in which the 6 patent offices have been asked to perform essentiality assessments. And the study finds, amongst other things, that there is an observed interest in transparent data on the essentiality of SEPs from implementers, patent owners, and courts alike, and that a system for generating such a data seems technically and institutionally feasible. As a consequence, the study then recommends to pursue the development and implementation of such a system for essentiality assessment. Now, I think that the study is definitely very welcome. I think it contributes significantly to clarify a complex issue, not least by establishing a better understanding what is actually meant by essentiality checks. But let me maybe share with you some insights of the EPO's approach to the essentiality assessment in the study. So the EPO has conducted 32 essentiality assessments in the pilot. This was the maximum number that was foreseen for a single patent office. These assessments were made applying a novelty type test. This means that contrary to more traditional approaches towards an essentiality assessment, we have simply assumed a hypothetical case where the standard document has already been published before the patent's priority date, and then to examine whether that document would have been novelty destroying to the patent applying the steps of a normal novelty test. So the approach is identical to what our patent examiners do on a daily basis when checking novelty requirements of Article 54 EPC. Our testers who participated in the pilot are very experienced examiners in the field of wireless communication. They have detailed technical knowledge and they have vast experience in dealing with SDOs and highly skilled in searching the standard documents on an almost daily basis. The EPO experts spend on average 2 to 3 days per assessment. However, the rules for the pilot did not allow the examiners to use some of the powerful tools which I've just described and on which they would rely on the real life circumstances. There were also other constraints in the pilot which made the job somewhat more challenging for the examiners. For instance, standard document which was supplied in the pilot was not always considered the most relevant to the patents that the examiner had to check. Other constraints included also, for example, that the specific assignment of the cases to the testers could not be influenced. This resulted in a situation that some of the cases were assigned to examiners who didn't have the best technical expertise to deal with that particular case. Something that obviously would not happen in real life. Also, the testers didn't have the opportunity to speak to the patent holder, nor were they allowed to speak with each other, which is also somewhat counterintuitive and not how our examiners typically perform their work. Finally, claim charts, which have been provided, were found useful by the examiners in certain cases, but sometimes they were also found as being biased and rather misleading than being of much use. Despite these constraints, the assessment made by the EPO resulted in a 79% consistency rate with the reference point chosen by the study. This consistency rate was identical of whether a claim chart was provided or not. This outcome of the novelty-based assessment was found by the study slightly more consistent with the reference point than the regular essentiality assessments, noting that the discrepancy was particularly high when no claim chart was provided. I should mention that the reference point chosen by the study was assessments made by patent pools, which obviously is not the absolute truth, but that has also been noted in the study. Now, we're currently examining the findings of the study and its results. It seems, however, clear that further investigation is necessary before any conclusions can be drawn, something that has also been emphasized by the European Commission when the report was presented last week. And I think that the content of the study provides already some valuable insights with regard to the possible design parameters and also some possible scenarios. But I think that specific use cases of any such essentiality assessment, including the possible trade-offs, certainly deserve to be further clarified. Specific use case obviously has an impact on the design and the scope of any essentiality tests. The concrete needs can diverge and they imply very different design parameters. For example, to name just one, the degree of thoroughness of the assessment, which is obviously a fundamental element, well, this can vary largely. Such tests may range from a simple patent landscaping exercise, where assessors spend 1 hour or even less to perform the tests, to a more detailed and thorough assessment similar to what the EPO did in the context of the pilot. But they can also range all the way down to an in-depth analysis, which involves legal interpretation of the definition of essentiality, claim construction, and even a possible consideration of the concepts such as the doctrine of equivalence. It's quite obvious that all these different design parameters come then with different trade-offs, and these trade-offs may or may not be acceptable depending on the use case. So a clearer understanding here seems necessary to answer all the questions, also such as who would be requesting such checks at which point in time, who would use them, and what for. Now, as far as the EPO is concerned, we will not take the responsibility of setting up an essentiality check mechanism on our own. And we're glad to see that this is not the mechanism recommended in the study, which rather suggests a decentralized approach to the exercise. And here the EPO will gladly continue to provide our expert support to the ongoing further reflection on the concrete way in which possible essentiality assessments could be set up. And we're very much looking forward to the discussion and to hear also the views of all the stakeholders. Now, before concluding, if I may take one more minute to add some information on some points that have been touched upon by Heinz in the previous panel, where, for instance, WIPO Mediation Arbitration Center has been mentioned as a possible forum to handle certain SEP-related issues. Well, I think since we have been talking a lot about Europe's competitiveness, I would like to mention that the Unified Patent Court, which is about to become a reality very soon, will also offer a patent mediation and arbitration center. Also, the future register for unitary patent protection will offer the possibility to include licensing commitments undertaken in standardization bodies by the holder of a unitary patent, which may also further contribute to transparency. And finally, let me also mention that a pending opposition at the EPO will not prevent the filing of a revocation action at the UPC. So you see, I think it's really about time that the last very few steps of this long-awaited European patent reforms are finalized and completed. And we're very hopeful that this will be done anytime soon. And with this short side remark, I've now reached the end of my short presentation, and I thank you very much for your attention.
Thank you, Michael. I move the floor over to Christian immediately. Christian Loyau from SEP, please.
Thank you very much, Nikolaus, and thank you to the organizers of this fantastic conference, which I think was falling at the right time after the different publication from the European Commission. So as Etsy is a little bit in the heart of the problem here, I will dig in the rule we have and what we're doing in Etsy and trying to explain why we welcome the initiative of the Commission, of course, and we welcome a thorough review of the essentiality. But let me first of all immediately tell you that Etsy, as one of the three ESOs, is not geared to conduct such review, and secondly, it's not in our statutes and constituency. So therefore, from the very beginning, let's say that we are not the body who could do such review. Thus, we have participated in the study conducted by Rudy Beckers on essentiality, and we will continue, of course, to help for finding suitable solutions. And why we need suitable solution, I think I will take you through some of our rules, Therefore, you will better understand why we think that this possibility to find some essentiality check are reasonable and welcome. First of all, if we are taking the ETSI IPR policy that is part of the rules of procedure, we have the basic article stating that when an essential IPR relating to a particular standard or technical specification is known, the patent owner, or I should say the owner of the IPR had to be prepared to grant a friend license. And going to the definition of IPR we have, IPR mean any intellectual property right conferred by statute law, including application. And there you can see we start by having maybe some lack of, instead of using the word transparency, I would use the word accuracy. Very fine if we have a granted patent, but what about a patent application? Can a patent application be essential? Sometimes yes, other times no. So there, by the rules we have already a certain uncertainty about the essentiality. I think there is no discussion about what essentiality is as defined by the ETSI IPR policy. That is clearly not possible on technical grounds to not use the equipment without infringement. So this policy is the fundamental cornerstone for the drafting of our standards. But I think it's important also to note that the policy of ETSI and the IPR database here is only an information tool. It has never been construed as a licensing tool, and the IPR policy here is only here to facilitate the standard making process in ETSI. So we have a certain number, of course, of our members declaring those standard essential patents in due time. But again, here the policy is intended to ensure that said IPRs are identified in sufficient time to avoid the wasting efforts of elaboration of our deliverables. I mean, that will be totally unproductive if the production of our standard could be destroyed by some owners of IPRs coming and declaring that they're not willing to grant licenses of their essential patents. So we are in a situation where, again, we only are informing the membership and third parties that there are a certain numbers of IPRs that needs to be thoroughly reviewed by the parties when they are negotiating their agreements, if they believe they need to negotiate those agreements. So this is also very important to state that ETSI has a fundamental role that is to be outside the commercial discussion. We are not intervening in those discussions, and therefore also you can easily understand that it's extremely difficult for us to intervene in the assessment of the essentiality. Another reason also will be totally clear for everybody. We are a membership-driven organization, and it's clear if we should have something to say about the essentiality, who then will have a say, or how could this say be organized in such a way that we are respecting the neutrality of the assessment. That is, in my opinion, totally impossible or extremely difficult. So therefore, that's another reason why we cannot conduct such essentiality review. Having said that, we need, of course, to find a solution, because if you're looking at the trend of patent declarations and the trend of producing of standard, it's exploding. And we have more and more companies declaring SEPs. So the policy and the way of functioning that was built back in the 90s was the first IPR policy in 94. Was maybe very fine at that time, where we were only discussing of standards that was or that were pretty simple compared to the standards and the technology of today. So the structure of our IPR policy cannot support that we are participating in any essentiality test. We, of course, provide quite a lot of information with, among other things, EPO. We have a very in-depth collaboration with EPO, where we're exchanging data on a daily basis. So on those aspects here, we can, of course, also provide information to whatever organization can be set up for looking at the essentiality of those SEPs declared. I just want to mention also why we see a need to that. And I want to just to refer to one case in France that started in 2015 between well, Conversant and LG about some patents that was deemed essential by the patent owner, of course. And the case was first ruled in first instance, and then it came to the appeal court later on. But as very often, the patent holder is picking up its best patents, of course, for getting either an infringement or the court to impose some friend rates. And here, in both first instance and in the appeal, the two courts found that the patents were not essential. They were valid, but not essential. The problem, I think, and because having discussed with different lawyers about that, and especially the lawyers of the defendant, the problem of the judge in this case here was that they received both from both parties expert reports. Of course, the one is stating that the SEPs are not essential, and the other one produce reports where it's explaining that they are essential. But nevertheless, at the end of the day, the judge has, or the court has, to take a decision based on opposite expertise. And in case of a court case, it may be very difficult for the judge to do that. I think that from a judge perspective, it could be easier if they could also have an opinion for such an organization that could be totally trustful, independent, and that will certainly ease, because I think that it's very important, due to the complexity of the technology we are standardizing here. It's important that each of the bodies do what they're best to do. I mean, the ESOs and ETSI are certainly best to produce standards. Of course, we receive those SEPs declaration, but again, it's only an information. Then, with respect to infringement and or setting friend rates, definitively courts or arbitration courts are the best to take a decision on that. And with respect to validity or infringement, again, courts here are also the best. What about essentiality? Are courts the best? Maybe, I don't know, but I'm certainly think that some third party, trustful third party, independent third party would, in most of the cases, be a very, very useful tool, both for the parties negotiating, both for courts in some cases, and also for us, standard organization, because then we could also get those information from those parties to increase the accuracy of the patents or the IPRs that are declared in our databases. So in conclusion, we are certainly welcoming any kind of bodies who could have a look at the essentiality problem, because as of today, it's true that the patent owners are declaring themselves. We are in a self-declaring system, which in some cases shows their limits to the accuracy of the system. Thank you very much.
Thank you, Christian. I move over to Monica Magnusson from Ericsson directly. Please, Monica.
Yes, thank you. Can you all hear me? I hope so. Yeah, your thumbs up. Thank you. I'm joining over my browser, so I've had a bit of a problem here this morning. Thank you, first of all, for inviting me to this session. My name is Monica Magnusson. I'm with Ericsson, and we do standards, cellular standards, for a living. We develop the technology that goes into the standard, and we sell network equipment, the stuff that enables your phone to come out of flight mode. I would like to start on this topic by stressing that patent holders do not declare essentiality. Patent holders disclose patents and then declare a willingness to license should that patent or application, for that matter, be essential. And in fact, it's voluntary. So if you would not like to license your patent or application, you say so. And that's the point with the whole thing. The standards body needs to know that standardization can go forward. Otherwise, the standards body needs to find ways of excluding that technology from the standard. That's the whole point with what we in daily speech call declarations. So they're not a list of essential patents. Then how do you know what's essential and what isn't? Well, if you're a big company that's been in this business for a while, then it's one thing. Then you do have a good understanding of the relative portfolio strengths of different companies in the market. If you're new to this field, obviously it's going to be an entirely different story. And if you're also a small company, very much different. So I'm sure there's benefits to be had from more transparency on this point. But I would like to stress up front that even if you're a small company, essentiality assessments or essentiality confirmations will only take you that far. They're not the only thing you need. For a start, an essential patent or what looks like an essential patent could be invalid, or they're not all equal. You could be faced with one portfolio with 3 patents that are incredibly valuable and another portfolio of patents with many, many patents, many of which aren't so valuable. Those are business considerations taken into account when you negotiate a license. A license which is usually global and usually covers a portfolio. As an implementer, I want a license to anything that the licensor has or comes to have, which is and remains or becomes essential during the term of the agreement. Then we renegotiate and we compensate for what happened during the term of the agreement. So essentiality is no silver bullet, but sure, it can be helpful to shed some light on what's out there that is essential and is not. I do think it's incredibly important that such assessment be robust, scientifically robust, rigorous. And by that, I mean you need the right competence. You need to spend enough time on analyzing them. If you do any form of sampling, that sampling needs to be statistically sound. And they need to be independent, obviously. I also believe that there needs to be a presumption of non-essentiality. You need to start from claim charts that the patent holder needs to submit to support their claim that the patent is essential, or the claim is essential, actually. And you need to set requirements for those claim charts. What makes a good claim chart? For that, for instance, you need to map every claim element to the standard, not just some major claim elements or anything. It needs to be solid. And at the end of the day, only courts can decide on essentiality, at least as the world looks now. So to incentivize patent holders to go through with all of this, I think there needs to be some incentives on the patent holder's behalf. There needs to be some quid pro quo where, I'm not sure how, but where for instance, the notion of willingness or unwillingness may be influenced by the fact that there is or there is not an assessed essentiality for patents in the portfolio. I think on the issue of patent offices doing essentiality checks or who should do essentiality checks, I think, again, the most important thing is that they're independent and rigorous and scientifically robust. But patent offices certainly have a good standing in terms of independence. I do think it's important, whoever does it, to build it up gradually, build capacity, build competence. And for patent offices, I think one needs to take a look at what the relationship to the basic mission of patent offices might be, might imply. And that needs consideration at least. And above all, if you're institutionalizing essentiality checks, hasten slowly. Build it up gradually. Think about incentives, quid pro quo. Think about the global aspects. And remember that 5G commitments have already been made. 6G commitments through a premature system where there's no trust are more likely not to happen than to happen. Look at the IEEE that changed its policy and all the negative letters of assurance that followed. I don't think we want to get into that kind of situation in ETSI. So above all, like Kerstin Jorna said earlier, this is about trust and building trust. Rigorous and independent assessment, quid pro quo for patent holders, and essentiality checks are not the silver bullet. Thank you.
Thank you very much, Monica. I'm moving the floor over to Beat Weibel from Siemens, please. Yeah.
Thank you, Nikolaus. I hope you can hear me. And thank you for having me. It's a great pleasure to be here. I would like to take the opportunity, as kind of invited by Kerstin Jorna, to shed some light and maybe some different light on things that we are discussing here, or maybe light from a different angle. And I would like to do that in 5 points. The first one is, what are we talking about? We are talking about SEP licensing. Kerstin Jorna once said, SEPs were a problem 5 years ago, and they are still a problem today. I think this statement is just too general, because there are many standards in the world where patents exist, and there are a number of standards where licensing of standard essential patents is no problem. I just would refer to, for example, video compression and coding, which is equally important to digitalization and where it seems to work. I will come back to this later. Number 2, over-declaration. We already heard it from Christian Loyau and Monica. Over-declaration is a term that and an allegation that some companies abusively over-declare SEPs that is very often heard, in particular in connection with the ETSI database. But as Christian and Monica clearly outlined, the ETSI database is by no means to be a reliable source of truly SEP patents. It's rather a declaration of potentially SEPs, and more important, it's a binding friend commitment. So to flip the coin over, you could also say for society, the more that is declared in the ETSI database, the better, because then the more patents are underlying a friend commitment. Number 3, SEP licensing is difficult and disfavoring SMEs, also a statement from Castiglione. Again, I would say this is only maybe, if ever, true for mobile communication SEPs. In other fields, as I mentioned, it seems to work. And why does it work? Because in mobile communication, in contrast to other standards, we have a lack of well-running pools. The LTE pool or the wideband CDMA pool are not really working. And there is not even an attempt to create the 5G pool. But why is this so? And I would say, I mean, that has to be studied, and it's probably better to study that than to take the efforts to roll out a full-scale essentiality check of the whole ETSI database. But one clear difference between the video coding pools and the mobile communication pools is that in the video coding, all the big players are part of. And in mobile communication pools, there are unfortunately not. There's one exception. It's the OneC pool mobile communication for automotive, where the main players are participating, but where the reluctance to make it a real success is rather on licensor side. So therefore, I personally think it would be better to use the resources, and the resources would better be invested to incentivize pool participation in mobile communication instead of scrutinizing and doing an essentiality check on a large scale of, for example, the entire ETSI database. Tax benefits on license income of certified pools or tax deductions for license payments to such certified pools would dramatically increase the attractiveness of such pools. And by the way, if we had such a European pool, this would make sure that Europe stays ahead in the position of standard essential patents, in particular in the field of communication. Everybody, licensors and licensees, as well as small and medium-sized enterprises, would profit of such an initiative, and it could be made sure that the technology remains in Europe. Number 4, who should do the essentiality checks? I think it's well accepted that the times are over where one could just submit patents to a pool. Nowadays, pools have the most elaborate essentiality check, but sometimes they lack acceptance. So the check that is performed in the pools could be regarded as the gold standard. Essentiality checks by an independent organization like a patent office could be an add-on and could maybe help out in terms of acceptance and trust, but it must be made sure that essentiality checks that are carried out by patent office, for example, are then really accepted in the patent pools, because otherwise a patent owner had to do two checks, which is a waste of resources. And number 5, infringement and essentiality. I agree, which is also said in the study, that essentiality doesn't mean infringement and vice versa. However, essentiality, according to my understanding, is a shortcut of a full-fledged infringement analysis. And this is needed because we have so many patents. That means if a patent is truly SEP and a standard is used, the patent is likely to be infringed. So in other words, essentiality and infringement belongs together, and they should be assessed at the same step. That means in particular before courts and in litigation. And at the same way, on the other hand, as nobody is carrying out large-scale infringement analysis in advance, the same should apply to essentiality checks, only when needed and on a case-to-case basis. And by the way, as Professor Meyer-Beck mentioned, essentiality is hardly litigated before courts. Christian mentioned one case, but that's the only one I'm aware of. The main issues that are litigated are friend behavior, royalty, is it infringement, etc., not essentiality. Therefore, I think that the thinking that the number of lawsuits will go down if the number of essential patents goes down is wrong. The number of lawsuits is not at all dependent on the number of essential patents. So to conclude, I would like to make the following statement. Instead of rolling out a large-scale essentiality check, I would rather suggest to carry out the study and learn why SEP licensing is working in certain fields and in other fields not. And based on that, since pools are playing an important role for getting access to SEPs, I would suggest that it is tested whether we could incentivize the creation and participation in SEP pools. Thank you very much.
Thank you, Bea, for very precise statements and also keeping time more or less. Thank you very much. Now, Tim Pohlmann from IPlytics. Please, Tim, the floor is yours.
Thank you, Nikolaus. Yes, my name is Tim Pohlmann from IPlytics. As many of you probably know, IPlytics is a database company. And for us, I think transparency is a very important point to make here. We do have publicly available declaration data. We have the full text standards. We even have understanding of standard contributions. And we can connect all these databases. But what is missing is, of course, an understanding of what is standard essential. So there's no public database of claim charts or patents mapped to standards. And that is something that I think would be important for the future. Being fully aware that not all patents declared may be mapped to standards by experts, but as to our view, it would be great if, and here I think any institution that is fit for the job could do it. And right now, patent pools, some patent pools actually in the video coding space, as Beat Weibel mentioned, they make that public. They have there is a list of patents, then the claims and the actual sections of the standards they relate to. And this is almost like a claim chart that they publish there. And this will be, that kind of information would be, of course, also very valuable in other technologies like the cellular space and the 3G, 4G, 5G, or in the space of wireless technology with Wi-Fi 5 and 6 and soon 7. And that's something that we think as a company that provides access to data would be a great step in the right direction. But today I also want to talk about something that we have been starting as a company, which is AI-based essentiality checks. And AI-based essentiality checks, for those of you who read the pilot study was also discussed in there, if this could be an approach for the future and what must be given to make this kind of analysis valuable. And I just quickly wanted to share with you what we've done at IPlytics and as a first step, but also, of course, telling you about the limitations. One of the things that was also mentioned in the pilot study of the EU Commission is that if we do such analysis AI-based, we need training data. And that's exactly true, what also we think as data experts. What we have created is a training data set of 1,000 5G declared patent families that we mapped to standard specifications by independent experts. Here we had experts looking at each patent family at least for 6 hours, and then we had a second expert confirming the charting. And as to that 1,000 data sample, we only see 15% essentiality rate. So something was earlier mentioned that a similar rate between 10 and 20% is expected, and that's also what we see from this sample. Another thing mentioned by Monica was if we do sampling and if we do look at only a portion, we have to do this with statistically verified methods. And this is also what we've done here. We did something like election polling, where we also asked just a certain number of people how they would vote when the next election is coming up. And we used the same statistical method here. So it was a random selection of declared patents. But the training data is balanced across portfolios, balanced across technology that you can, for example, identify by the actual different specifications, for example, relating from different standards groups like RAN 1, RAN 2, and also in terms of filing dates, basically differentiating between the different technology life cycles that you can look at. What we did then is we trained the data with a semantic model. Also, this is very important as claim language comes from patent attorneys. And we all know patent attorneys are trained to use broad language. And that language is very different to the language that an engineer uses when they specify something like a 5G technical specification. So the training data is very important here to have a semantic model adapt those differences. And as you probably know, semantic models these days, they don't care about keywords. They care about vectors. And vectors is exactly what is important here. So even if a certain word isn't used in a claim or in the section, the algorithm understands the context. And that was then integrated in an AI-based prediction model. And our first results have shown an actually very interesting and good result that we only have a 5% margin of error. To put differently, out of 100 patents that our scoring scores in the top scoring numbers, out of these 100 patents, 95 of these patents were later found by experts to be mappable to actually standards. But the big question is, of course, is this as good as an expert, right? And I think the clear answer is no. The kind of essentiality test that this algorithm is doing is there a relation of the claim to what is mentioned in the standard section? But we do know that essentiality testing can also go beyond that. Is that standard implementation of a certain product actually using a certain thing of that section, etc.? So it can be a lot deeper. Also, there are, of course, cases that are a lot more complex, that complexity cannot be captured by an algorithm yet. I mean, I think it's a good start, it's a great start, but we are not there yet that we can replace experts. However, as you know, many of our clients using our declaration data, which we all know is subject to over-declaration, we have first clients that have been using our AI approach to pre-evaluating their portfolio. And why is that interesting is if you think about 5G, we have almost 40,000 families declared right now. So it is impossible for any expert to do actual claim charts on these. So an automated process pre-filtering and pre-evaluating those declared patents helps very much to focus only on the top scoring patents, which allows you to more quickly and more cost efficiently do claim do claim charting tests. So that's the outcome of our first approach here that we have been using. And we've been sharing that with different clients and different experts in the industry. And so far we have first good results, but I think also here, it is worth mentioning we are not there yet. And one big issue here again, I think that was also mentioned earlier a couple of times, is trust. Because we have to be aware that a system like this is somehow a black box. And the reason why is an AI-based model is using training data, and that training basically allows the algorithm to adapt something that is known from humans, to adapt that to a larger proportion of data. And that is something that the human mind cannot easily recreate, right? You cannot re-engineer that algorithm and understand precisely why a certain patent is scored high and the other one is low. Of course, in theory, we can explain it, but not in detail. And not in, we will not have someone in a court sitting and explaining, in detail why that one claim is matching that one section. So I think that is still a big issue, that these kind of approaches are not being comparable to an expert who can also testify in court or rephrase his analysis, these kind of things. So that's something we have to be all aware of, that these systems have limitations. There was something mentioned in the pilot study that there is a fear that some companies may understand this algorithm, trick the algorithm, that they have always high scoring patents. People who know what AI algorithms are is exactly, I mean, it very much depends on the training data. And if the training data is biased, there is a chance. But AI algorithms are exactly unpredictable. And it is harder to understand how an AI algorithm comes up with a higher score than an expert. So I think that is a worry that I don't see much. A worry that I do see much is making sure that the training data is really unbiased. Our training data was from external people. We paid them, not our clients paid them. This is very important. So I could see that if we, for example, would use data from a patent pool, who kind of represents the view of their members, people could see that being as a biased sample. Or, essentiality tests coming from single patent owners might be seen biased, because of course they would see their own essentiality claim charting in favor. So we need really third-party institutions. I think patent offices would be a great solution. And I think it's important that if they do claim charting, that data should be public, because that makes also everyone look at it. And maybe even confirm it. We also have, things like the crowd of the experts out there. So a public claim chart that can be commented by others, other experts, maybe could even be, a common approach to look at this. Yes, to sum it up, there are first approaches. Happy to answer any question if there's any follow-ups on this one. Thank you very much.
Thank you very much, Tim. I'm looking at time, and we're running out of time essentially. So I mean, so I will use the remaining time just to go individually back to each of you with one or two questions, and then I would appreciate a very quick answer on that. Maybe just follow up on Tim. I mean, you've laid out, I think in a very thorough way, the AI possible approach, what can be done, also of course the danger of black box, but then you came back to that, yes, I mean, it's actually the patent offices that are needed in order to build trust. But I mean, you're on this panel also because obviously because you're representing a company that could potentially contribute to a system of examination, for instance, with an AI-based approach. But so to speak, how can you see then yourself being linked into a system of trust, if there is any system? You representing an SME that is providing services in this field.
Yes, I think for us, trust is important because we are not serving one company's purpose. Our clients are SEP owners, same as SEP licensees. So we are in between those, those people. And I think the goal for us would be not to be in one position or the other, but be a neutral source in between, be that independency, right? I think that is what we see our position in. Providing transparency on all databases, that is important. giving people access to information, and then giving some information beyond that, indication of what this could be. I think people that use patent analytics tools, there's also valuations of patents in there. And then I think that is also something that we know has limitations, and so will this AI approach have limitations. But it's still used. People use it in the industry because often it is not feasible to have experts look at single patents all the time and write reports that cannot be maintainable. And again, also those experts can potentially be biased sometimes. So I think having, we have these systems today. I think we should have a look and support those. You know, maybe even we could you know, give suggestions ourselves of what and provide data on scores if that is requested. I think that is something for sure we could do. But of course, we have to be a little bit careful. Everything that people cannot understand and, you know, re-engineer will always need some trust. And I think that's the way to move forward, to creating that trust, to also hear out experts. I mean, that's what we have been doing the past years, talking to experts, understanding their issues and also their thoughts about such approaches. And that's, I think, something that we want to keep doing. So anyone who has a critique about it, I think, or sees potential risk, that's very important to understand what that could be.
Thank you. Now, Beat, I mean, you've been promoting pretty much the established model of patent pools, and also incentivize, making the point that, you know, if we set up more patent pools, maybe specialized patent pools, this would be a way to promote Europe, but also European technologies. It could be done by technologies and so on. But same question to you in a way. I mean, this black box thing, you know, about, isn't that also the case with patent pools? I know that they're, for the time being, they are of course, obviously the established authority as for essentiality checking. But who outside of a pool knows what is going on within the pool, and how can this be integrated, or could be integrated into another system, or in general transparency be reasoned within such a system?
Yeah, I mean, I agree with Tim that the transparency is important in that respect. But the reason why I'm promoting pool is because if you're putting yourself for once in the shoes of a small and medium-sized enterprise, what they need is access to the SEPs, and they need reliable access, and they need reliable royalties in order to calculate them. But they don't really, that's my opinion, they don't really care whether they license 500 or 5,000 SEPs. It's just a matter of that they get access to the majority of the SEPs, and that they get it at a reasonable royalty fee. That's the main interest for companies that have to take these licenses. And in order to do that, I think we should promote pools, and at the same way make clear that it's not a black box, but that it's a transparent and reliable process and offering.
Thank you. Monica, you've also emphasized, you know, trust, and of course there is, it came up in also from other participants, the issue that, of course, you know, it's the quality is and trust is somehow as a trade-off with the effort that is put into the system, and related to that is simply the price. I mean, so where would you put a reasonable price level, you know, from an industry perspective for such testing, if it were be set up anywhere? So I mean, we have reference data now from patent pools, so going up 5,000 to 10,000 euro per patent family. So I mean, so where would you put a threshold from where on it makes sense? You also have your in-house, of course, obviously experience doing essentiality checks and claim charts yourself.
With all respect, Nikolaus, I think that is starting at the wrong end, or picking the stick up by the wrong end, so to speak, because what is a reasonable cost absolutely depends on what you get for your money. If you're getting something really high quality, you're going to be ready to pay more. If it's too low quality, you're not going to be ready to pay anything. So I think, again, it's more important to ensure that these checks are rigorous, that they can be trusted by the entire ecosystem, licensors and licensees alike. I do think it's incredibly important to start from a presumption of non-essentiality. I don't see a point in checking anything that has been disclosed to standards bodies. That will be throwing money into thin air. But if you start from requiring claim charts by patent holders, if you start from a presumption of non-essentiality until you've proven that all the claim elements are mapping to the standard, if you do the essentiality checks robustly enough, if you build the competence gradually, build the capacity, if you make sure you spend enough time on doing the essentiality checks, we may get to a point where this could add value to the ecosystem. But I think there are far too many question marks on fulfilling those requirements. And we need to do that first before asking ourselves, can we do that at a cost that's manageable? That's a later question.
Thank you, Monica. That was a bit provocative, but I think you're absolutely right that it's a matter of the of the quality what you get, which is linked to the price, and let's try to fix that one first. Okay, oh, fine. Christian, you've made a clear statement that it's not Etsy, and I think probably most people would agree on that because simply you don't have the expertise, you know. But still, I think, you know, Etsy has a very important role, of course. I mean, as in the field we're talking about, the main field of telecommunications, and we're talking about it's you're the kind of the master of the data, I would say. I mean, that's, you get the data and you're the host of the data set we are discussing here. I mean, it's not intended, the data says that is now with Etsy, it's never been intended for licensing. But that was also mentioned, I think, Beat, you said that, and that's absolutely correct. So, but thinking about a system, of course, then of checking at some point, you know, there would be a database where, you know, the essential patterns would be in there. So, and I do believe that as for, you know, the host of the data, I can imagine that Etsy will have to play an important role there. Maybe could you say on the data side a few things on where you could see a role of Etsy in this game?
Yes, Nikolaus, of course, we can improve very much what we're doing at this stage here. But again, I would relate essentiality most to the definition we have, because as I mentioned to you, we have a rather vague definition of IPR. I mean, it's patent and patent application. But I want to put a question here. Can, for example, an unpublished patent application be essential? But we are taking on board such declaration. And this is discussed. It's currently discussed within our IPR committee, of course. But you can see that it creates some uncertainty and a lack of accuracy again about the database we are providing for the membership and everybody, as a matter of fact. So there are some improvement that can be made. We also have improvement with regard to the declaration itself. I mean, the linkage between the patent or the claims of the patents, for example, and the part of the standards or the technical specification. We have extremely large debate about that and very opposite opinion on this factor here. But obviously it would help, of course. Is it reasonable to do it or not? It's not to me to ask this question, of course. It's the membership to decide. But I can see points where we could improve that and could ease the solution of having a better view, a better assessment of what is necessary for the negotiating party to know.
Yes, thank you, Christian. Now, Michael from the European Patent Office, Just two quick questions. One is, I mean, it's always coming up this, only courts can, after all, decide, and that's also what we propose in the pilot study there. It's the courts that at the end will always have the last word. There's no doubt about this. But still, I mean, if we compare essentiality to something like an examination process at EPO, I mean, it is also, I mean, you have appeal and opposition possibilities, and then at the end you can go to court. I mean, and for infringement questions, in any case, you have to go to court. So, and it's the national courts, and so, I mean, what can you say a few words on the possible legal status that's of such an essentiality test? I don't see so much different personally, but I'm not a lawyer there. That's the first question. And the second one, if you might share some insight, because you were referring to the use cases of essentiality tests, possible use, and that is of course related to the level of thoroughness of the test, right? Maybe you could share also, that would be interesting, some insights that you derive from the 32 cases that you have examined and the level of effort that was spent into it in order to get an idea, okay, for such an output, I mean, what do you get in terms of level of thoroughness? And that would then lead, we're not going to discuss that again, I'm not asking that question again, to certainly to a price level, but I mean, I think once you have the level of thoroughness defined, that will probably, and the quality, that's what I take away from Monica's answer, that will then define then the price somehow. So I mean, some insights into the sample there, that would be interesting. Thanks.
Thanks, Nikolaus. Yeah, I think you're in a provocative mood in asking these questions. Obviously, I think they're good questions though, but I must somewhat disappoint you here because we have not engaged in any concrete preparations for the setting up of essentiality checks. So we haven't really given any consideration to the question of what would be the legal effect, for instance. But I mean, since you're asking about the legal status compared with the EPO patent granting procedure, I would refer you to the saying that consulting the law sometimes simplifies the search for justice. So applied here, this means that the rights under the EPC and the PCT obviously only apply to the official proceedings relating to the grant of a patent. And this also includes the subsequent challenges of a position and appeal. Now, when reading the EPC and the PCT, you will realize that essentiality checks are obviously neither part of one nor of the other. I don't know if this answers the question. But as regards to the second element, yeah, here again, I mean, given that we haven't engaged in any concrete preparations, hard to say anything with that regard. I think, again, it's maybe premature to check these type of questions and focus on these questions. But let me just recall that, you know, we will analyze the findings of the study, but there are obviously a number of important points that still need to be clarified in more detail. But to respond to your questions, you know, not made any kind of cost calculation so far, but as a general rule, an activity by the EPO which is not foreseen in the EPC must be budget neutral for the organizations, therefore always calculating the full cost price.
Mm-hmm. Thank you. Thank you, Michael. No, I think we're just in time now. I think I'm very much sorry for realizing that, you know, we have no time for Q&A with the audience. That was intended to, and we will apply the, you know, we have the polls here. So we're putting up the polls here. That's okay. So yeah, where people can participate quickly if they want. So everybody who's still here on this, you know, with us, you know, can participate on the poll, and that might provide us then with some useful information, at least from, you know, from an audience of almost 200 people still on the line here. As for the specific questions that have been asked now in the Q&A section here, again, we will as much as possible, we will forward them to the people, and then maybe get back to you after after the conference. And now I would like to, so while the poll is running here, I would already like to give the floor to, move the floor over to Knut Blind for